Check, check, 1, 2. Testing.
Alright, we're live. It's just sitting on the
Check, check. Mic check.
Mic check.
Mic check.
That's funny. Oh yeah. 5 minutes.
chime in.
Okay. Same thing, I'm not gonna.
All right, we're recording, so we're just going to start whenever you're ready.
Okay, yes. I know, I have that problem.
Ensure to
Get over it real fast.
and secure the blessings of liberty and
We, the people of the United States,
in order to form a more perfect union,
establish justice,
ensure domestic tranquility,
provide for the common defense,
promote the general welfare,
to secure the blessings of liberty,
To ourselves and our posterity,
Do ordain this Constitution
for the United States of America.
What's up, everybody? Welcome to OC's series called Order in the Court. Today we have a Constitution Day edition because not today, but on September 17th will be Constitution Day. And just so you know what Constitution Day is, it is supposed to honor when the 39 Founding Fathers signed the document that we now refer to as the United States Constitution. And I'm excited because that was an awesome video, and that's the first time we saw it too. So definitely give those students a hand because that video is awesome. I'm also excited because the other part of Constitution Day is not only to recognize when the Constitution was signed, but also to honor and recognize American citizenship, whether natural born, naturalized. So because of that, we're going to focus on civil liberties and civil rights, and I'll talk about what the difference is here in just a sec. I'm excited to also introduce the panel because we have a diverse group, including 2 students, which is awesome. But first of all, my name is Daniel Regalado. I teach government and history here at Odessa College. I will start by introducing the panel, starting to my left. Ryan Ledbetter is a government instructor here at Odessa College. Professor Ledbetter holds a Master of Arts in Political Science from Georgia State University, a Master of Public Administration degree from the University of West Georgia, a Bachelor of Arts from Jacksonville State University, and an Associate of Science degree from Southern Union State Community College. Professor Ledbetter's research interests include campaigns and elections, political psychology, and public human resource management. Please help me welcome Professor Ledbetter. And moving on to Ryan's left, we have one of our students, Liliana Macura. Is that right, correct? Liliana Macura is a freshman from Austin, Texas, and plays the middle position with the OC volleyball team. She plans to transfer to a 4-year university and is considering pre-law as her major. Please help me welcome Liliana. Where is yours? And Kelly, I'm just going to wing yours because to hers, we have, to Liliana's left, we have Kelly Smith. Kelly Smith is a professor of history here at Odessa College. And I apologize because I didn't pronounce your bio, but please help us welcome Professor Smith. And then to my right, we have Professor Zimmerman. Autumn Zimmerman is a historian whose primary research is in discrimination. She received her master's degree in history from the University of Texas of the Permian Basin in 2021. Her thesis discussed discrimination in competitive speech and debate and analyzed how discrimination, gender-based, race-based, and socioeconomic-based in microspheres leads to discrimination on a macro level. She received bachelor's degrees in history, speech communications, and quantitative analysis from Kansas Wesleyan University in 2019 and was a 3-time national debate champion. She has also interacted extensively with politicians both at the state and federal level. Zimmerman now teaches American history at Odessa College. Please help me welcome Professor Zimmerman. And to Professor Zimmerman's right, we have the other student. Britney Hicks is originally from Bossier City, Louisiana. She moved to this area 4 years ago with her husband and decided to re-enroll in college to finish her degree. This is her 2nd year at OC studying psychology, and she plans to pursue counseling to help steer others in positive directions. She is a member of Phi Theta Kappa and the National Society of Leadership and Success. And I love this quote she sent when she sent me her bio because I think this is spot on what we want to part of the things we want to accomplish today. But she said, I am no history buff by a long shot, but as a citizen, I do have an interest in identifying what has or has not worked in the past and looking at how to or how not to implement that into our future. So please help us welcome Britney. And last but not least, we have the Honorable Judge Sarah Kate Billingsley. She is the presiding judge of the 446th District Court. Please help us welcome the judge. So, as I mentioned, Constitution Day is to honor when the 39 founding fathers signed the Constitution, which of course gives us many different rights, but I do want to make sure we understand the difference between civil liberties and civil rights, and we're going to talk a lot more detail about some other stuff, but the basic definition you get is a civil liberty is protection from the government, and as we progress through this conversation, you're going to see lots of examples of that protection from the government. And then civil rights, as I always tell students, kind of think about the civil rights movement, what it was about, and civil rights is protection from discrimination. So y'all probably know this, but if you don't know, we've actually had two constitutions in regards to the United States, and some of y'all might remember the first one called the Articles of Confederation. To give you the very short version in regards to what happened there, we had an event called Shays' Rebellion in 1786, which basically showed that the Articles of Confederation were inefficient and there were some flaws there. So the Founding Fathers called a meeting in Annapolis, but only 12 delegates showed up. Which obviously is not a lot. From 5 states, 12 delegates from 5 states. At the time, there was obviously 13 states, and more or less anywhere between 60 and 70 delegates, but only 12 showed up from 5 states. So there was an issue in regards to we can't progress if only 12 delegates show up from 5 states. But we know that Shays' Rebellion proved that there were some issues with the Articles of Confederation, but I'll point this to the panel. What were some of the problems with the Articles of Confederation?
I mean, each state works independently of one another, so there's no real idea of what a nation means. The Articles of Confederation doesn't identify us as a nation. And so each had their own currency, laws, interstate commerce becomes a problem. The government's in charge of foreign relations and maintain a military but can't collect taxes. So basic sort of building blocks of a country. The government is unable to do, and they have to ask permission from the states who work independently of one another.
Right. And I think one of the things I like to discuss in my course is like, what if Texas could trade with Russia? You know, how would that work? If Texas just independently was able to trade with Russia, and what if Texas didn't honor its debts to Russia? Then what would be the role of the federal government? So I think one of the things we learned, because I like to consider the Articles of Confederation a learning experience for the early United States, is that we do have to have some sort of centralized government. And that goes back to the argument of what we're going to talk about with Federalists and Anti-Federalists, of how strong that central government needed to be for us to be a successful nation.
So what about those Anti-Federalists and Federalists? What was that about?
The conflict between the Anti-Federalists and Federalists was really a conflict over the United States Constitution. Your Federalists were individuals who preferred a strong central national government, and that preferential sort of treatment really enforced a support for the U.S. Constitution. Whereas the Anti-Federalists were on the convergence of that. They didn't really support the Constitution. They believed the states should maintain power, should have control over these things largely, because ultimately they felt that after separation from Britain, that a strong centralized government was just going to yield the same sort of tyranny, the same sorts of abuses as a strong federal government in the United States could, because if the wealthy were still in power, it only made sense that they would still remain tyrannical regardless of whether or not they were from Britain or domestically from the United States. Your key Federalists were people like Alexander Hamilton, George Washington, Benjamin Franklin, whereas the Anti-Federalists more likely consisted of people like Patrick Henry, Richard Henry Lee, John Hancock. Those are some of the famous Anti-Federalists. So you can see, analyzing those two groups of people, how their ideology sort of differentiated. Because as we know, Washington was the forerunner in the revolutionary forces. He's one of the people that we associate with the revolution itself and being the founding forefather of the United States.
So if you didn't know, the infamous, of course, we all know the name George Washington. He actually presided over what is now referred to as the Constitutional Convention, also called the Philadelphia Convention. I had mentioned that at the Annapolis Convention, there was only 12 delegates from 5 states. At the Constitutional Convention, you end up having 55 delegates come and go from 12 states. So not all the states showed up, but 12 out of 13 obviously is a lot better than the 5 states. Rhode Island had to throw it off for everybody.
They go to the beat of their own drummer.
So we have this September 17th, when the 39 signers of the document, we have the establishment of the Constitution with 7 articles, and as I was explaining to students, articles kind of think of them just like subheadings. But the question I always ask students is, well, then how many amendments did the original Constitution have? And obviously the answer to that is 0, because an amendment is some kind of addition or alterations to the document. So we know, or you probably know, that the first 10 amendments that were added were changes, so they weren't included in the original Constitution, and we referred to, of course, the first 10 amendments as the Bill of Rights. And we know that the Bill of Rights have very important rights, constitutional rights, that we honor: Texas right to bear arms, right, freedom of speech, those kind of things. But why weren't they included in the original Constitution if these are obviously the first 10 amendments?
And I think the easiest question to that is, they felt like that the Constitution had granted very specific powers to the government, so it was almost as if, well, that's unnecessary if we're only saying that the government can do these things. Of course, going back to the Federalist issue, that was sort of one of our early pieces of political propaganda, the Federalist Papers. That pamphlet that was distributed, you know, if you think about how important that was to how we disseminate political information today, it was much harder back then. So they were able to get a lot of people on board with this. But, you know, they didn't feel that the Bill of Rights was necessary, you know, as I said, because they thought, well, the government can't stop anyone from doing those things. But really, it was essentially meant to be a blanket of protection that each person knew and understood their rights, because it's unrealistic to expect everyone to read the Constitution and understand everything that's in it. So I think it was just a simplification of rights and just a major expression of what that meant to be an American citizen at that point.
Well, that's why James Madison writes it, because he doesn't want them at all, and he's like, well, if we're gonna have it to get the Constitution passed, I'm gonna write it myself, because then I'll make it vague enough, maybe in some cases too vague, for interpretation or whatnot, so that I'm not limiting rights. And so he's like, I'll do it because I hate it.
Most definitely. And it was also a piece of legislation that would allow the Federalists to get the Constitution passed. The reason that the Constitution passes is because of the Bill of Rights. Without that Bill of Rights and without the allocation of civil liberties into the United States, the Constitution would have never passed.
Yeah, and that goes back to our early forms of politics in the United States. You know, we had to get buy-in from more states and from more people, specifically like Rhode Island and North Carolina, that didn't want to ratify the Constitution without the Bill of Rights being present.
I think also the Bill of Rights is a good place where everyone knows their rights. They all read it. Whereas the Constitution, I've never read the Constitution. I know what it vaguely says in there, but I can tell you what every right in the Bill of Rights says and what it means. So I think that it's an overview of everyone so that everyone knows their individual rights.
Absolutely, good point.
And of course the Third Amendment, which we all use every day.
Quartering troops, man.
What is it? Yeah.
It's only been used like once in the whole history of it, and it was like 2 years ago.
So my joke is, if you don't know, the Third Amendment is, you know, prohibits us from being required to quarter troops. So I always like to crack jokes about that in class, that, you know, you use that amendment every day, whether you realize you do. And, you know, Kelly even has a good story about how it was used recently.
It was used a couple years ago when, during protest movements, the president deployed troops into Washington, D.C. and placed them in various hotels without working out prior agreements. And immediately the mayor of Washington, D.C. was like, you're in violation of my Third Amendment. And immediately troops were withdrawn because they'd never been used before in the history of the United States. And so no one was really sure if what was transpiring was actually quartering. But they also didn't want a constitutional crisis, and everyone agreed that it would probably vote in favor with Washington, D.C. And so immediately, like, she was walking off the stage from her press conference, and they had already issued, like, retreat of military soldiers. And that was the first time, like, since Boston, pre-American Revolution.
Pre-Bill of Rights.
So I told you the difference between civil liberties and civil rights, and some of y'all have already mentioned the concept. So let's talk about civil liberties first, and then we'll see transition to civil rights. But civil liberties, remember, protection from the government. And as Liliana pointed out, there's a lot of important rights you have in the Bill of Rights. So it was hard to decide where we were going to start. But I wanted to focus on the concept of freedom of religion, mainly because of something that's come up here lately in the news. And if you're not familiar, Texas recently passed a state law that basically mandates that the schools have to post a "In God We Trust" poster in front of their, somewhere in the school, and it has to be somewhere where you can actually see it, not in some corner or something like that. So I know when I brought this up in class a few times, students have been like, well, one, I wasn't aware of that law that just started here in September, but also how does that relate to freedom of religion? So just really quick, there was one of my favorite Supreme Court cases I like to talk about when we're talking about freedom of religion is a case, really old, Reynolds versus United States, 1878. But basically Reynolds was a Mormon who practiced polygamy, and federal law claimed polygamy was illegal. Reynolds claims his freedom of religion rights are being violated. This goes to the Supreme Court, and basically the question here is, do you have the right, as far as freedom of religion, do you have the right to believe in what you want to believe? And we know now that yes, you do have the right, but you can't break the law. So the court rules against Reynolds, saying basically you have the right to believe what you want, but you can't break the law. And the cheesy joke I always tell my students is, you have the right to believe human sacrifice is going to get you wherever you want to go to, but you can't actually practice that, right? So, so in regards to freedom of religion, and I'll point this to the panel, any other cases or issues that y'all can think of that pop up?
I mean, I'm the Kansas person, so I guess I have to go into Snyder v. Phelps.
Yeah.
So Snyder v. Phelps also capitalizes not only on freedom of religion, but freedom of speech. If you don't know who Fred Phelps is, he's a very prominent religious leader at the Westboro Baptist Church who commonly protests military funerals. And they protest them because of the larger conflicts. They claim that war is going to damn people, and they claim that the tolerance of homosexuality inside of the United States is going to basically send us all down under instead of up above, those kinds of things. And in order to protest this inside of the United States, they've decided to protest it in the form of protesting military funerals, because homosexual individuals have been allowed to maintain military status. And so because they disagree with this, they started with Alfred Snyder's son, who was a lance corporal who died in 2006 in Iraq. And they publicly told the church, who was presiding over the funeral, that they were going to protest the funeral. They held up signs saying that the military was going to cause God to rage down on the United States, and that these public issues were going to basically cause all of us to go to hell, for lack of a better term. And they would post signs that says, God hates the United States, God hates the US, so he sent the terrorists to attack during 9/11, those kinds of things. And as a result, Alfred Snyder ended up taking it to court. He felt that this was a violation of his mental health. He felt that this was a violation of his son and of things that really caused a lot of emotional turmoil inside of him. And so he takes it to the Supreme Court, arguing that this violates his inherent right to happiness, first of all, because ultimately having a good funeral for his son is something that really should have been prioritized, but it didn't happen. And so he takes it to the Supreme Court, and Fred Phelps ends up coming to the Supreme Court and saying that he has the right to the freedom of speech and the freedom of religion, because his religion is adamant that people of the LGBTQIA+ community should not exist, and his church is also adamant in the idea that publicly supporting these ideals and this form of ideology is going to result in a bad scenario for the United States. And because they were doing this on public ground in a public way, and they weren't privately attacking the Snyder family, but were rather publicly arguing over public issues, they decided in an 8-1 Supreme Court decision that the Westboro Baptist Church did have protections of religious values and of freedom of speech, and so they could not prevent them from protesting military funerals.
Awesome. Any other favorite cases or comments on freedom of religion?
I think a recent one, the Kennedy versus Bremerton School District case. This is a recent example from this past year, where a coach, if you aren't familiar, wanted to hold prayer at midfield and exercise what he felt was his religious right, and he was terminated from his employment for it. And to keep it short, the Supreme Court said that he was within his rights under the First Amendment to practice his religion. And to me, I know this case sort of went under the radar, especially because of the recent Hobbs ruling, which we'll talk about later. But I feel like that case kind of slipped under the radar in a lot of ways. But that is a really important case to how we view religious freedom in the United States, in my opinion, because I think the Supreme Court saying that it's okay for you to practice it. It doesn't matter what your employment status is or what your position is, that you have a right to practice your religion. I think it opens up a lot of, I think we viewed this as sort of a narrow window before, and I think it widens that window a lot in a lot of ways with cases like this.
I think the Supreme Court has a pretty tough job in that any court is required to not legislate from the bench. There are 3 branches of government, very distinctive for a reason. And quite honestly, you don't want any of us legislating from the bench. I don't want to pretend like you should. But I think that the Supreme Court has a difficult job in that they only accept certiorari on certain cases, and so they only hear certain cases. And when they do, a lot of times those cases involve more than one of your inalienable rights. And so when you look at that and decide the balancing act in which you have to perform, because there's nothing to say that your First Amendment right is more important than your due process. And as a judge and as a legal person, I would tell you that is not the way that should go in that balancing test, that anyone's due process is the most important. But when you're looking at Supreme Court decisions, especially when they involve more than one inalienable right, which is something from the Bill of Rights that you are born with, that you get automatically as a United States citizen, and that those ideas are non-negotiable. They can't be trampled on. You shouldn't waive them. They're non-negotiable. And so when you do have those decisions, I don't envy that position, but I think it's important to always remember that one doesn't necessarily trump the other, ever. That they're all requirements, that they're all important, and that there really just isn't one that's more important than the other. So when you have one person saying that I have the right to assemble, I have the right to free speech, I have the right to freedom of religion, and then another person that may trump another one of those inalienable rights, those things are hard, those decisions are hard. And that's why we have a Supreme Court and a justice system, but it's always interesting. I'm a big legal nerd, so I love to read the opinions. It sounds like you guys are too, then. So maybe I'm with people. But I find that fascinating, really.
Absolutely.
To try to weigh those out.
And that goes back to we're all in a social contract with one another and with the government. So when we're talking about due process and what that means with our expression, and Dr. Regalato's example of human sacrifice and things like that, we're in a contract. We give up certain things in order to have certain protections, and those protections are given to us in the Bill of Rights, but we also have to give up a certain level of freedom in order to exercise those rights for everyone, and for everyone to have the equal protection, which we'll talk about here shortly too.
I think it also goes back to Kelly's point earlier too, because we noted that the amendments to the Constitution are a little bit broad at some points, but the Constitution itself is also very broad, especially when it discusses the judiciary. The judicial branch of government had to basically formulate itself. It was identified and created by the Constitution, but its responsibilities and what it was meant to do were never really allocated or aligned in the Constitution.
And I think sometimes that's really nice, and other that was probably on the nose. No, so I think sometimes that's really nice, and then I think other times that just like anything, something that can be a pro can also be a con.
And then as you're going to see as we progress, though, it's really hard to add things and to acknowledge glaring omissions and have the template of how you're supposed to fix it and be met with such resistance. And I think the three of us later will be discussing sort of the conflicts that arise, and that it seems simple enough. We've amended the Constitution a lot to address deficits, but not necessarily.
I think it should be hard though.
Yeah.
To amend the Constitution.
Oh, yeah.
That's not something that should change with partisanship.
100%, yeah.
Right? And so, that is something that could change with partisanship if it were easy. And there's something about having consistent, stable rights that you know that you're going to have every day when you wake up. There's a real peace of mind to that. So.
And that goes, the part of it being difficult prevents us from having what's called legislative whiplash. You know, every 2 years when Congress change, or every 4 years when the president changes, you know, we could have legislative whiplash from that. And that's what, you know, an example of that would be Texas. You know, to do a lot of things in Texas, we have to amend the Constitution, and it's been amended 517 times. Obviously, a lot easier to amend the Constitution in Texas than the U.S. Constitution, and that is for a reason, because some people might say, well, we could do this. You know, people bring this up about the Electoral College, but that's not as simple as it seems, and it's difficult for a reason.
Well, and I think the Constitution being broad is a good thing because it's made it sustainable for the last 200 years. It's made it to where it adapts to what we need, because we've changed so much since it was written, but it still is very prominent in how we run our government today.
And the United States is the first and arguably only country in the history of the world to have a revolution that doesn't devolve into a dictatorship, because the Constitution and how we have set up, and that you can evolve and adapt. But like, think of that, like the first and arguably only time in all of human history that people overthrew a presiding government and formed a new government that has lasted and not ended in a dictatorship. Some have lasted a little while and then always devolve into an imperial power comes back, or a dictatorship comes and takes them, like military coups or anything like that, and somehow we've persisted, which is quite a remarkable feat for a bunch of people who didn't know what they were doing. Like they had to create something out of thin air, and nothing like the U.S. has ever existed before, so they really had to, I mean, they have a lot of faults, but at least they created something that we can navigate through.
And they create it for good reason, because if you look at the abuses in the revolutionary conflict, some of them are gruesome. Like, you can be hanged for violating the Tea Act or the Stamp Act, so you're not paying taxes on all of your paper goods, or you're buying tea at an increased price from a domestic colonial purchaser. And so the civil rights that we've been given through the amendments to the Constitution are a very, very valuable piece of legislation that without, we would still probably be devolved into conflict and controversy and things of that nature.
Right. So some of y'all brought up the Equal Protection Clause and mentioned the phrase civil rights. So I guess this is a perfect segue to switch to civil rights, because we could do this whole thing on civil liberties, and we could do it on freedom of religion, let alone all the other civil liberties. But I do want to touch up a little bit on civil rights. And remember, civil rights protection from discrimination. The way I was explaining to students in regard going back to the 14th Amendment's Equal Protection Clause is that's the civil right of all civil rights, right? Because the Equal Protection Clause basically is that. Everyone is equal. Everyone has the same rights for it. But I think most of us are familiar with the American Civil Rights Movement. Would anyone on the panel like to discuss, just give us a quick overview of what is the civil rights movement in the United States?
Oh, that's right in my wheelhouse. It really depends on where you choose to start with civil rights. And if I chose to start at the beginning, I would probably take about 3 days up here to explain it to you. But I'm going to start with Plessy versus Ferguson, because that's where the modern civil rights movement really kind of picks up momentum, because Plessy versus Ferguson establishes the separate but equal clause, which basically means that for people of color, as long as a separate institution that provides the same services of the same quality exists, that you can have segregation within those schools and within offices and businesses and anything else, really. And so Plessy versus Ferguson really establishes the civil rights movement in the United States, because there are several people who realize that these separate institutions and these separate entities are not equivalent. And as a result, you have a case where these individuals are stepping out in defense of that. Plessy versus Ferguson gets challenged in several ways. It gets challenged in courts, it gets challenged in the educational system. Specifically, it starts to get challenged in the Irene Morgan versus the Commonwealth of Virginia case, because Irene Morgan gets arrested because she refuses to give up her seat on a bus that is transporting her between state lines. When she refuses to give up that seat, she's arrested, and she ends up taking it to court, basically says, you know, I don't have to abide by this because it's not a specific state that owns this bus line. I'm not staying inside of a specific state. Therefore, this is interstate commerce. And as a result, you cannot subject that to segregation. And she ends up winning. The Supreme Court ends up upholding her end of the case and ultimately siding with her, saying that yes, this decision is going to be ruled in favor of this because you cannot segregate interstate commerce. Now, in order to determine whether or not that case actually gets upheld, the journey of reconciliation takes place. And the journey of reconciliation takes place when 8 African Americans decide to test whether or not Morgan versus the Commonwealth of Virginia is actually going to exist and be supported and really be upheld inside of states that have segregation. What they find out is that, of course, that doesn't happen because segregation still ends up taking precedent. It still ends up taking control. So Plessy versus Ferguson is still upheld, segregation is still upheld, and as a result, we dive into a series of legislative attempts to really overturn Plessy versus Ferguson. And the real first step in doing that actually involves the University of Texas. Some of you probably watched some of the football games yesterday. And the case is called Sweat versus Painter. And in Sweat versus Painter, Sweat sues the University of Texas because they refuse him admission into law school. Now, when they refuse him admission into law school, he takes it to the Supreme Court, and in answer, they tried to create a separate institution that will provide him a law degree because he is African American. So they try to create an African American school. But it's ruled by the Supreme Court in Sweat versus Painter that the educational quality and that the relationships that he could form at the University of Texas would not be equivalent to what they would be at another institution. So if they created this secondary institution for people of color, that he would not have the same opportunities to interact with current politicians, current legislature, current lawyers. And as a result, they rule that the separate but equal doctrine is not necessarily always upheld, and therefore Sweat versus Painter becomes the first real attempt to overturn Plessy versus Ferguson. Now, the real case that overturns holistically Plessy versus Ferguson is the one that everybody knows about, and that's Brown versus Topeka Board of Education. In the Brown v. Board of Education case, an individual is attempting to go to a public school because that school is closer to where she lives. It is less expensive for her to get there, and it's more convenient, and it provides a higher level of education than the schools that they're trying to force her to go to. And so Thurgood Marshall, who is the chief counsel of the NAACP at this time, argues the case, and SCOTUS rules that segregation in public schools is unconstitutional holistically, because a separate institution for people of color, even looking at it on face value, is obviously not equivalent to what was in white neighborhoods. And a lot of that deals with things like taxation in neighborhoods as well, because a lot of the higher, wealthier people at this period of time are living in primarily white neighborhoods, and taxes are directly funding those schools. And so in the white neighborhoods, you have higher taxation rates and higher taxation income, and therefore you have higher quality schools and institutions. Whereas in the African American neighborhoods, schools are few and far between, first of all, and second of all, they're not getting as much revenue or support. But after Brown versus Board of Education is ruled, and after segregation in schools is determined to be completely invalidated, the Little Rock Nine become prominent. The Little Rock Nine attempt to basically test out whether or not segregation in public institutions is really at an end. And they go to high school, in a public high school, and the Arkansas governor decides that he doesn't like that very much. So he calls in Arkansas's National Guard and attempts to basically prevent these 9 individuals from going to school inside Little Rock, Arkansas. When that happens, President Eisenhower, though he formally believed that the Supreme Court should not be involved or make decisions on segregation, ends up saying that we need to go in, we need to do something because they're militantly trying to keep these students from going to school, and these students are being subjected to abuses. So he calls off the Arkansas National Guard, and he basically calls in the U.S. Army and tells them that they have to escort these 9 kids into the high school. At the end of 1957, one of the Little Rock 9 ends up graduating and becomes the first African-American student to graduate from Central High School in Little Rock, Arkansas. So we see a little bit of progression there with regard to civil rights and civil protections. However, the Brown versus Board of Education case really sets off a tipping point for aggressive white militant groups inside of the United States, specifically within the KKK. There's a lot of white backlash that occurs after Brown v. Board of Education is implemented and after it is ruled on. And they're very frustrated because they believe that incorporating people of different skin colors into schools is going to harm their children, it's going to cause them to be impressionable, and it's going to cause them to believe in ideals that they shouldn't, which we know today is not true. But that's their sentiment. That's what they were ingrained to believe at that period of time. And so the Emmett Till case ends up becoming an answer to Brown versus Board of Education. So in 1955, Emmett Till, who was a 14-year-old boy from Chicago, ends up going to Mississippi to visit some of his family. And when he goes to Mississippi, he stops into a convenience store that's run by white individuals. Keep in mind that Till has absolutely no idea what segregation practices are like in the South, because he's been raised in Chicago. He goes into the store and he allegedly, we found out recently that this is not true, but he allegedly ends up catcalling a young white woman behind the counter, ends up having an interaction with her, and is claimed to have touched her in some not okay places. And this white woman, after Till leaves this convenience store, tells her husband and her brother-in-law the story. The husband and the brother-in-law are not necessarily too fond of that. And so when they get told this story, they decide that they are going to sneak out at midnight. They're going to kidnap Emmett Till from his family's home, and they are going to brutally murder him. Emmett Till is not found for 3 days. His head is smashed in, it's caved in completely. You can barely tell who he is. And he's basically just discarded into a river. His mother ends up getting wind of this because they figure out who he is. She's sent down to identify him, and she does indeed confirm that Emmett Till is her son. And she is really the person who starts, or encourages, I should say, more people to get involved in the civil rights movement, because she decides that she is not going to hide these abuses from the public. She decides to have an open casket funeral, and she decides to call the media in, because she thinks that these abuses should really be shown to the broader public. And so she has an open casket funeral for her son, and she allows these news outlets to record and to videotape and to show these images to the broader public of the United States, and ultimately these images get broadcasted internationally as well. And it's gruesome. There are individuals there who go, and every 4 individuals, one of them ends up fainting or crying or vomiting because of the brutality that Till was subjected to, even after Reconstruction in the mortuary. And it's very, very brutal. The civil rights movement ends up really, a lot of times in high school education and in college education sometimes, I think the brutality gets a little bit covered up because we're uncomfortable talking about these things. But as it is Constitution Day, and as we are talking about civil rights, it's important to realize what these rights protect us from, because civil rights protect us from these abuses. It shows that these things are not okay. And Emmett Till is one of the high-ranking cases that we really need to evaluate when we discuss civil rights and what they're meant to curtail, because we can't allow that to happen.
Absolutely, and I mean, like you said, we take these things for granted, but a lot of us in this room wouldn't be sitting here if you know, based off our past, or even next to each other, or in certain spots. So absolutely, thank you for that. Any other 2 cents on civil rights?
I wanted to talk, so sort of growing narrative currently is the Equal Rights Amendment. The women's rights movement started, the marker seen as the Seneca Falls Convention in July of 1848. A group of women and abolitionists got together. The women's rights movement and the abolitionist movement are linked because both groups want full recognition under the Constitution. It splits for a variety of reasons, racially based reasons, as we move through. Following the passage of the 19th Amendment, which was ratified August 26, 1920, women like Alice Paul wanted more. And so the first Equal Rights Amendment was first introduced shortly thereafter because women lacked basic rights. They were essentially property in their marriages or through their fathers. They had no access to court systems, bank accounts, property. So they introduce, it fails, and then it continues to pick up. And in 1971, led by New York Representative Bella Alzig, and feminist icons Betty Friedman and Gloria Steinem, a new Equal Rights Amendment was introduced. And it quickly passes both houses of the Senate with bipartisan support and goes to the states to be ratified in 1972. Hawaii is the first, and you have 30 states afterwards, but you need 38. And for some reason, I mean, there are probably lots of them, Congress placed an expiration date on the Equal Rights Amendment. Keep in mind, the 27th Amendment, our most recent one, which deals with congressional salaries, was ratified after 202 years and several months from the moment it was introduced till when it was passed, but I digress. By the time the amendment expired, they had 35 states. In the intervening years, culminating with Virginia's passage in January of 2020, the 38 states have been reached, and it's still languishing. There was lots of controversies about this. One, the bill's expired. There have been bipartisan bills introduced to lift the expiration date. The Trump administration said no. The Biden administration's like, we'll support a new amendment. Others look at things like, if we're equal under the law, what about things like the draft? So women would be drafted, but then would you add in protections for things like sexual violence, particularly in combat zones when other foreign nations use that as a separate sort of war crime attribute? Will there be protections in place? Others say that the 14th Amendment and the Equal Protection Clause, which Liliana's going to talk about too, that if you pass a separate amendment saying that women are less than, that we're different, that we don't fall under the 14th Amendment, are you reaffirming this idea that we need special protections, that I should be protected under the 14th Amendment, that I'm a full citizen under the law and granted the rights therein? Others, including women like Ruth Bader Ginsburg, who are huge champions of the Equal Rights Amendment. But it was introduced in 1971 when women had very little rights. And we have a lot more rights today. And so there is a growing belief on both sides of the aisle that we just need to, it's great that we have these 38 states, although 5 have tried to rescind the ratification. So there's some debate on whether or not they're legally able to do that because they had already previously voted. But because things like the Violence Against Women Act and Title IX, that we don't have the same, we have lots of concerns, but they're very different from that my husband was responsible for my health care and that I couldn't get a credit card or open a bank account. And so sort of how that revolves and sort of the complications of that you can support the amendment, but maybe we should just start again. And then Liliana. So
you mentioned Ruth Bader Ginsburg. In one of her early cases, it was Sharon A. Frio and Joseph, I'm going to pronounce these names wrong, I'm not good at names, but versus Elliot L. Richardson, which Sharon was in the military. She was married to Joseph, and in their marriage, she was the breadwinner. She earned 3 times more money than he did. She was in charge of all their finances. She was not their typical stay-at-home, like I'm gonna work. She had a job. She was very, very well off. And the military denied Joseph any of her spouse spouse benefits, and he was not allowed to get housing through the military. He was not allowed to enjoy the medical benefits of being in the military, which is a lot for the women at the time. And so they decided that they were going to sue and say that this violated their equal protections rights, and that just because she's a woman in the military, he does not get the rights. And they actually did a survey at the time, and women in the military were making considerably more money than the men in the military, but their spouses are not getting any of the benefits that the female spouses were getting from the male counterparts. So the defense said it's because the males are usually independent, and your female spouse is at least half as dependent, half of their income is dependent on the male, where in this case, Joseph was not half dependent on her, but he also did not spend a lot because she provided everything. She bought everything. His expenses were very low. And, I believe that this case, though, shows the double standard that just because there's a female in the military, they expect that the male is still going to be earning his own money and still going out and supporting their family, that the female will never be the one that is supporting the family solely and the one that provides for the children and all of that. So they ended up, after they were out of the military, that ended up passing this law that both parties, no matter who is in the military, the spouse gets the benefits no matter what.
And that's something Ruth Bader Ginsburg did a lot in her early cases, was flip the narrative that men would pay attention to sexism when it was against them. So all of her first cases in front of the Supreme Court were all dealing with male clients using laws that were designed for females, and then they can get benefits for various things. And so she was like, they'll pay attention now if I use it again, like their own laws against them, to prove that sexism works both ways, essentially. And it really sort of revolutionizes the women's rights movement now she has on docket through the Supreme Court of these double standards between men and women and how the laws are written. Well, you've already done precedents now, and you've already ruled in favor of the men, so now if you don't rule in favor of women, we know why. So it's an interesting sort of flip on how she gets things done.
And then earlier you said the Plessy versus Ferguson, that separate but equal is constitutional. There's also a case in the women's rights where they tried to use that, where women were being denied enrollment into the Virginia Military Institute. And so the Virginia Military Institute started another branch that was solely for women, and they tried to say, well, it's the same branch, it doesn't matter whether they're going to it's still the Virginia Military Institute, but it was ruled in a 7-1 decision that that is unconstitutional to have two separate branches of a school, because they're not going to get the same interaction with their peers and the same enrichment that comes from having people with different ideas in your same school.
Which parallels that Sweat v. Painter decision too.
Mm-hmm. So do we feel gender discrimination is still around?
Yes.
Definitely.
Period.
And we still have a little bit of like a gap in our pay as far as for women and men too, for no other reason apparently than our gender. So I think that's ridiculous.
Or that even women being in charge, or like overly emotional, or like depiction, like if you ask people why women should be president or anything like that, well, we would just start wars. And you're like, well, all the wars have been started by men. And they're like, but women are just too emotional to be in charge.
We do love a good war.
Yeah.
I mean, the pink tax also exists too. Like, you can go out and buy a razor that's colored pink for a woman, or you can go out and buy a blue razor for a man, and the woman's going to pay 3 times what the man is for the razor. Like, we talk about the Revolution and the Constitution, and half of the reason that the Revolution gets fought is because of unfair taxation without representation, and here we are.
Ruth Bader Ginsburg has a good quote. It's, "Be a lady and be independent," is what she lives by. She says, be a lady, don't let useless emotions as in anger, don't yell, don't raise your voice, be posed, and no matter what you're saying, but be independent. You have your own thoughts in your head. You have your own ideas, and don't be afraid to express them.
So I'm being told we have 5 minutes left. I want to see if we have any questions from the audience. Does anyone have any questions for the panel? Dr. Lee?
Hi, Ian Lee, I teach history here. You guys spoke a little bit before. I guess, we started out with 0 amendments to the Constitution, and now we have 27. I was just curious how difficult it is to have a brand new amendment implemented into the Constitution. I guess last time it happened was in the early 90s, if I'm not mistaken. So that was like 20 years ago. But I guess, what's the process for that, and how difficult is it?
I would say right now it's almost impossible. Polarization has been increasingly becoming more pernicious over the last 30 years, the us versus them mentality. We talked about why it's difficult to pass amendments and these 3/4 and these 2/3 requirements, but it goes back to what people believe and what people are listening to and what they're buying into as far as politics. And you have, Diverger's law talks about, why our current, electorate favors a two-party system, but we're becoming more polarized, and that essentially means that getting any sort of brain trust together that would be able to do that just seems super unlikely at this point. I can't imagine an amendment right now that would gain widespread bipartisan support.
Even the Equal Rights Amendment, they voted to, the House has voted multiple times to remove the expiration date, and it will stall out in the Senate and there's even bipartisan support of bills written, and they can't get anything done to make it to like the next phase.
Everything stalls out in the Senate.
Yeah.
Any other questions? Final thoughts, panelists? We're down to 3 minutes.
I think we should all the Constitution is sort of, in the United States being this sort of grand experiment, like I said before, that we didn't evolve into a dictatorship. I don't think any of us should ever take that for granted, and that we can change the Constitution, and you should get involved and express your rights. The Bill of Rights offers lots of protection for things that you care about, to work both in sort of a grassroots level, and embrace it. Find causes that are important to you, and try and get, if you see something is lacking or missing or support or people need a voice, the First Amendment will cover all of that for you. Just don't break the law in the process. But like, find your space and what's passionate for you, and you can make a difference. Things in the grassroots level in your local community are just as important on the sort of the big scale. Things get done in local communities and then sort of move out from there.
And without getting too political science-y, but when you think about the Constitution, there are two schools of thought, and the people on the right and conservatives view the Constitution as very literal. It is what it is. We should take it at its word. And people on the left view the Constitution as it's a living document. It should evolve over time. And we talked about it being polarized. Well, until it becomes less polarized, those viewpoints are going to keep us from making many edits to what's currently there.
The only way it's going to become less polarized if more people get involved and they express their opinions, because then more of the consensus will bring the two sides back together, instead of having this, well, I don't agree, so I'm not going to vote. You're just making the polarization worse.
Absolutely.
Well, and you guys are all smart. Look at this room. But on its face, there are so many minorities in this room. Women, people of color, there's some age. If you look around the room, look how beautiful this is. And this is so new. This has not been a thing for 100 years. I wish that it was, but it's not. So know your rights. Know why we draw the distinction between a civil liberty and a civil right. Know that a civil liberty is something that the government can't do, and that a civil right is something that a government must step in to protect a minority group of people. Know your rights. Know what you're entitled to. Know what you stand for. Know how you can stand up for the things that matter to you. And so it's really, really important, so that we can continue to be minorities in these rooms, to be whatever it is that we want to be. You have the right to life and liberty and the pursuit of happiness here in America, and that's meaningful, and that does mean something. So know where you come from and know where you're going and know exactly how you get there and what your government can and can't do to prevent you or to help you. It's important. We draw that distinction for a reason.
Well said. And I think we are out of time. Thank you once again for either watching live or attending here our second episode of Order in the Court, Constitution Day edition, Civil Liberties, Civil Rights. Thank you very much.
Happy New Year to Odessa College students. There's still time to register. You can talk with an advisor online. We have a virtual advising center, and you can find that on our website by clicking Register Now and scroll down to the Virtual Advising Center. And don't forget, in October, you can start in Fall 2. Fall 2 starts October 17th, and we'd love to see you